Hi, everyone. If you want, you can put your introduction in the chat box, and that ways we know who all are joining us today. And you can also put in your location from where you are joining us. So it'll be an interesting thing to know from where people are joining us today. We still have 1 minute to go. Akansha, is my network all right?
It started breaking all of a sudden. It was fine earlier.
I think now it's fine.
Yeah.
Akansha, it's 8:30. Let us start. Yeah.
Okay. Good evening, everyone who's joining us from India. Good morning, good afternoon, if you're joining us from different parts of the world. On the behalf of the entire team of Accords International, I welcome you all to the Fireside Chat with Ekta Bahl on Mediation Bill 2021. Now, this topic we know has been explored a lot, but we try to bring in different questions which have not been asked as of now and see how this mediation bill, which intends to promote mediation in India, provide mechanism to facilitate mediation, enforce the enforcement, promote the enforcement of settlement mechanisms. So we'll see how that has been done. Before we move on to the chat part of it, let me just introduce you to our guest. We have Ekta Bahl, who is a partner with Samvad Partners and is the partner in charge of the Hyderabad office of the firm. She is a corporate commercial lawyer who has significant experience in corporate restructuring, insolvency, private equity, and mergers and acquisitions. Ekta is also passionate about mediation and is a qualified mediator. She was a part of the team which was invited to give comments to parliamentary committee authorized by the chairman of Rajya Sabha to submit a report on the Mediation Bill 2021. She has completed 40 hours of mediation and negotiation training from both the Indian Institute of Corporate Affairs and the International Center for Alternative Dispute Resolution. She also has completed the Specialist Mediator Workshop conducted by SIMC and is a member of Specialist Mediator Panel India of SMIC. Thank you, Ekta, for joining us today. And with this, I would hand over to Upasna if you want to add anything.
Thank you, Akanksha, for that wonderful introduction. Thank you, Ekta, for joining us. And now I would like to add Satvik in spotlight. So he will be your interviewer today. So he's a final year law student. I think he will introduce himself better to you. And the floor is yours. Please go ahead.
Warm good evening, ma'am. Myself, I'm Satvik S. Reddy. I'm studying fourth year BLLB honors from MIT Law School, Noida. I'm a part of Accords mediation from past 2 months, and this is my first fireside chat, and I'm pretty excited because I never took any kind of interviews before, and it's going to be, as it is a fireside and informal chat. I was a little bit relaxed later to know about that part. Ma'am, I'm like extremely happy to take interview of such a person who has done extremely well in this mediation thing, and like nowadays many students from field of law are getting inclined towards mediation and other procedures of ADR, alternate dispute resolution, if I say. And mediation is one of such core procedures of ADR which can save, according to me, like so much of amount of time to judiciary, and people of India are even shifting towards settling the disputes outside the court. So this mediation bill 2021, which was introduced in Rajya Sabha, is like pretty, according to me and the students of law, is a pretty big step and bold step in the field of law. And we would like to know what kind of implementations, I mean, what kind of development can it do in the field of law in the upcoming years, ma'am? And if I may, I can start. We can start with my first question.
Yeah. Ekta, you're not audible. Yeah. I'm just removing the.
Is it audible now?
Yes, ma'am.
Okay, perfect. So I thank you for inviting me here. And Satvik, I'm really looking forward to interacting with you.
Thank you so much.
Yeah.
Yes, ma'am. Before we start by asking some questions on mediation. We would like to know about your journey, ma'am. Like, why did you choose mediation as a profession? Like mediation, like I can understand that 15 years before from today, like there was no such emphasis of ADR on the general population of India. And how could you find mediation at that point of time in your life? And how could you create an impact in mediation and ADR procedures over the period of time? Like what made you think that one day mediation will be the future?
Satvik, versus I'm not a dinosaur. The way you're saying that, you're like, that time. It's not so long back.
Yes.
If you look at the history of ADR in India, okay, and ADR actually has been that we talk about the Arbitration Act and Arbitration Conciliation Act now, but we had an Arbitration Act in 1940. No, we had an Arbitration Act in 1940. So ADR is not new in India. And even if you talk about mediation, we talk about mediation and conciliation as modern day words. But if you look at the concept of dialogue, of conversation, we've had, even the Vedas talk about it. So I think as people, conversation and resolving conflict to dialogue has been there for eternity. It's just that we slowly moved into, imbibing and using primarily the adversarial system to resolve conflicts. And dialogue became, let's have conversations at home or a cup of coffee, but it was never institutionalized. It was not considered to be a mainstream way of resolving conflicts. It was like, if you thought of conflict, you thought of adversarial. You never thought about, let's try through dialogue resolving conflict. And I'm intentionally not using the words mediation or conciliation because these are words that have sort of crept into our modern day language, and
that is true.
And the organization, the firm I work with, Samvad is also, it means dialogue. So it's all about conversation. But having said that, my journey to mediation is actually relatively new. So I'm actually a corporate transactional lawyer. My life is spent negotiating on one hand and mediating. They're sort of complementary in several ways. And so about 10 years ago, so even though mediation, the MCPC, etc., has been around for about 15 plus years in the country, my tryst with mediation is about 10 years ago, is when somebody actually told me that, they use mediation. We'd seen Arbitration Conciliation Act. We were like, okay, fine, arbitration and conciliation is there, and like all law students and people of profession, we read it and we looked at it very technically, procedurally, without understanding. And I did not really understand the true sense of conciliation. So it was at a round table conference that, there were two very senior mediators who actually gave a wonderful session on what is mediation and, how does it impact and what it's all about. And that was something that it was like, a light bulb in my mind went off, and that's it. That's me. That's something that I can associate with, because I've always believed that, people can talk things through, and we just have to understand where the other person's coming from. So when my journey of mediation started around then, the biggest challenge, at least now you have, 40-hour trainings every here and there. 10 years ago, there was hardly anything.
Yes,
so, and then my aha moment came when IICA said, okay, fine, we are now taking no mediation trainings across India. And that's when I did my first training. And then I keep studying. So I'm very nerdy when it comes to reading and understanding things about mediation, because I believe that 40-hour training is just, it's like giving a preamble or an introduction to the subject. And then it's a journey to understand people. It's a journey to understand dialogue. It's a journey to understand conflict. And I'm still on the journey. So it's continuing.
Yes, wonderful to know, ma'am. Ma'am, if we go to our second question, like I wanted to ask you, like, what are the three things like you like to know about? Like now, if you come to the subject, like, what are the three things, ma'am, about about the proposed bill, and what are the three things you should not absolutely be say like not part of it?
It's a very, Satvik, that's an interesting question, but I think it's also a very difficult question to sort of answer because I don't want to go nitpicking into the bill. And
Like I just wanted to ask,
yeah,
like,
so
what are the
I'm
three
going to.
good things of this
So
bill, and what do you think?
So I think number one is, and which is a challenge we have today, is when you talk about mediated settlements and we talk about settlement agreements that parties enter into, the enforceability of that is still a question mark. Okay, with the mediation bill, that is something that is sought to create a validity and enforceability of the mediation process of the settlement agreement itself. And for me, that's a great thing. The second thing is we have more clarity in terms of how processes should be handled, in terms of there's confidentiality, there is neutrality. So, and so that process, has been identified. That process there's clarity to the process. So even an upcoming mediator might be shaky on a lot of things and won't have clarity. Today can at least look at the mediation and bill and think, okay, I need to ensure confidentiality. Okay, I need to look at neutrality. I need to understand neutrality. So there's clarity which is given there. The third thing is there is a sanctity given to institutions to handle mediations in a more efficient manner. So there is a recognition of institutions. While a mediator might mediate, but there's also sanctity given to institutions. And institutions will, I believe, sort of help take over the burden from the government, from the judiciary, on certain aspects. Because even if I say, yes, let's do court annex mediation, how much can court annex mediations handle? And court annex mediations, again, are limited by several factors, which will not be, which a private institution may be able to overcome in terms of whether it is territoriality, it is jurisdiction. They will be able to do crossovers between countries, territories, states much more easily than a court annex mediation. So I think for me, these are broadly three positive things about the Act. There are several more, it's not that this is it, but for me, this sort of is the crux of it. When it comes to challenges and when I look at mediation, today when we talk about mediation, we talk about commercial mediation, we talk about, mediation for the privileged, larger words. But if you look at, when you look at the court cases pile up or when you look at conflict, there's a large number of people who are not able to address grievances simply because they're not able to afford it. There are large-scale community issues. So while the mediation bill touches upon community mediation, I think it's a very half-baked, half-hearted attempt to plug it in. And it's like, it needs a mention, so I've mentioned it. And that for me is disappointing. I would have liked to see more on community mediation because, and when I'm talking about community mediation, it's not just looking at neighborhood issues, you'll have restorative justice come out of it. And how do you look at that? And that brings me to the next issue. And the next issue is when you look at this entire things you cannot mediate, our entire first schedule. Now, the first schedule itself, because if you look at resolution of issues, people can actually resolve through dialogue anything else. Even if you look at a fraud or a murder or, a homicide or anything which is a criminal intent because of how the government, how our IPC looks at it, even those issues can actually be resolved through mediation. But the only thing that comes is, and I understand where, the government is probably hesitant to say that you can mediate anything and everything, is that some of these things, especially if, especially if it has a larger public issue or a public morality impact, okay, there maybe need to be at least a court oversight over it. So some of these issues, you could have actually brought in court oversight rather than saying a blanket, you cannot mediate, or these are not mediatable things. So for me, that discomfort comes that if you put so much there, so, a lot of things will go under the carpet. You will not be able to mediate. For example, I'll give you a simple things like an oppression mismanagement case in which might be there before the NCLT.
Yes.
Now that can be mediated. There's no problem on it. But if you look at the history of the dispute, probably happening over 15 years, and it could be a family dispute between two brothers, triggered to a company dispute, which is oppression management, that is mediatable. Now the brothers are after their lives. They will have filed criminal complaints for fraud, for attempted murder, for all this. Those are not mediatable. Now and if you look at the interest of the parties in all of this, it will actually be that, we had a misunderstanding. And that misunderstanding through accusations got embedded in our system. Emotionally, it stretched us apart and it drew us further. And if we had the conversation over mediation, we would have realized that there is actually nothing to it and our relationship is preserved. So your first schedule actually doesn't even take into account some of these issues where the main issue is not necessarily a criminal offense, but it's a byproduct of the adversity between the parties because of the long-run dispute. The third thing is, my concern is at some point, the mediation process is also getting steeped into bureaucracy and is becoming bureaucratic. And I'll give you two examples of where it consists. And one is, if you look at this entire thing, that the mediation agreement needs to be registered. And I understand that, that there could be a reason that I need the registration because I have visibility as to what are the statistics I'm dealing with. And I think there can be other ways to do that rather than saying registered or not registered. Because with registration comes what? You can have confidentiality issues. You probably have registration fees coming in, which becomes, which already today we find that people are saying, I have another layer and another payment structure to satisfy before I can actually resolve my dispute, because mediation doesn't give you guarantees. So you're adding another layer in terms of for registration. The second thing is, if you see how the council itself is structured, while there are only 2 of government officials, the rest of the body is also appointed by the government. So then how do you look at, would they be retired officials who've probably done a mediation training who will come in? So will that again, and if you get a bureaucratic council, then the procedural issues then creep up. And then the worry is then how do we look at the process? Because the council is the one which will have a larger impact on how mediators are appointed, what institutions do. And then will that get more and more bureaucratized? So these are 3 broad buckets of my likes and my hopes for improvement.
Definitely, ma'am. These are definitely truly evident in all the ways we see in the mediation currently, in the current scenario. Yes, ma'am. Ma'am, if you go to our next question, ma'am, do you think is litigation mediation mandatory under this bill? Like, do you think mandating mediation goes against its nature of voluntary nature if you mandate litigation before?
So there are 2 views on all this, and I'm a fence sitter when it comes to this. Okay, so while I believe that parties should have the understanding and be made aware of the benefits of mediation, but forcing them to sit through a mediation session itself goes against the principles of mediation. So I would have preferred, rather than calling it pre-litigation mediation, you could say pre-litigation mediation counseling, where a party goes through 1 or 2 sessions of mediation counseling where they're told about, that is mandatory. It means you need to come through that counseling session where a presentation is given to you on the benefits of mediation and how it works. Where the parties can probably say that, these are 3 mediators I would like to meet with, where they can go and interact, and the mediators don't necessarily have to come to court. The parties can go and say that I would like to speak to these 3 mediators, and those calls can happen over Zoom, or they can go to the mediator's office and figure out and get comfort with the process, and then take a decision. Do I? Don't I?
Yes, ma'am, I agree.
So that is the way I look at it. Because then when they see, at the end of the day, they have to trust the process. They have to buy in the process. And if they're not able to buy in the process, then everybody will go into mediation, forget the dispute. They will go into mediation saying, Are Baba, what am I supposed to be doing here? Why am I here? I don't want to do this. Okay? Because they are not sensitized. And the more you sensitize people, then it becomes part of a process. Then people don't think about. But at the beginning, you need to give them comfort. And the other challenge with pre-litigation mediation is do we have enough mediators to take on the volume of the mediation that happens? Like I have seen pre-litigation mediation coming up before a mediator over a year after the reference has been filed. Now, those kind of things, and we talk about access to justice, we talk about, not having to deal with delays, and mediation is a tool that you don't delay. But if the first session for mediation comes after a year, you might have had completed about 6 or 7 hearings in the process. So then you defeat.
Yeah. One thing which I want to ask here, Satvik, if you allow me, and Ekta,
yes, ma'am. Yes, ma'am. Definitely.
So, thank you. And I think definitely the number of trained mediators is an issue, Ekta, and I think infrastructurally also. I don't think so. The courts in India are prepared for pre-litigation, making pre-litigation mediation mandatory. And also, is it mandatory only in commercial matters or also in family matters? Is it explained there?
So therefore the thing is, what the and that's very interesting of the mediation bill itself. So the mediation bill, though it says it tries to consolidate mediation in the country, it still has these little things out. The Commercial Courts Act mediation continues the way it is. Family court mediation continues the way it is. So I have these little streams of mediation conducted under different legislations, which will continue the way it is. Okay, and then everything else can be under this. So, but having said that, and when we're looking at, it's not that we don't have trained mediators. We do have a reasonable amount of trained mediators. But if you make it mandatory pre-litigation for all sorts of disputes, or at least all sorts of, say, civil disputes, will the number of mediators that we have today be enough? Okay, and that becomes a big question. Secondly, when you talk about infrastructure, technically for mediation, I need maybe a table, chair, and place where people can sit. We don't need anything more. But can the infrastructure that we talk about is, I still need the registry to handle cases. I still need that machinery to function. So my machinery there, is it equipped to suddenly say that, okay, fine, now all these matters, I need to number them, give it for mediation. At the end of the time period stipulated, I need to follow up and say, where are you? So those are the questions that do come about. So it's not that mandatory pre-litigation mediation, you shouldn't have it or should have it, but it's like, can we handle it? And then do we do it at one? Do we do it, stage-wise? Like today we've already, and I think the biggest learning will be, how do we see, we've had the Commercial Courts Amendment Act now for a while. It's not something that's, that the mediation bill is the first time we're seeing pre-litigation mediation coming in. We've had the amendment to the Commercial Courts Act, 12A was introduced. Okay, and what are our learnings from it? Has 12A been successful? What are the statistics of 12A? I think we need to study where we are at 12A before we say we should do it or we shouldn't do it. And if 12A is very successful in some states and not in the others, why?
True, I agree to that. I think 12A matters are coming to the court and ex-mediation centers. I agree with that, but definitely a study is required to understand in what states. And I think that is a brilliant perspective, Ekta, that even if it is working, then in which states is it working? That's a second layer of study that is required.
Yeah, because 12A is not successful in all states.
Yes.
12A, some states are insisting, some states wait for a party to file a Form 1.
I think that's a brilliant thing, because some states, how to handle conflict is also different state-wise.
Yeah.
People's. So I think that's a brilliant point made there. Thank you. Satvik, please go ahead.
Yes, ma'am. That was certainly a very good insight for us on how the pre-litigation mediation works, and the very good insights on the way we take it forward in our country. Ma'am, if you go to our next question, ma'am, what are the kinds of disputes which are excluded from the purview of this bill? And do you think, ma'am, this bill should have included these disputes?
This is, in fact, I mentioned that earlier. One of my pet peeves I can't really pet peeve. One thing I wish was handled better was in terms of how do you look at which are the disputes that can be mediated. To my mind, or every conflict can be mediated. Now, the question actually comes is, that what are the terms of settlement that I have. Now, if the terms of settlement are violative of law, okay, if the terms of settlement are against a certain, against, say, public security or national security, if the settlement causes harm to someone. And when I'm talking about violation of law, I'm not talking about violation of a FEMA provision, etc. While that is also there, but violative of, say, the law on immorality or indecency. Why? Of course, that's a different discussion altogether. That should we have those kind of laws? But there could be larger implications. There's a violation of, say, it's a violation of POXO Act, or which are very, very serious offenses. Now, if you have a mediated settlement agreement that goes that part, then you need to have statutory oversight over what goes in. Now, so to say that, if there's anything which deals with fraud cannot be mediated, and the example I gave earlier, it could be a family dispute, but because the parties are in dispute for 15 years, you'll have criminal cases filed by every person against every other person. Now, it doesn't make it necessarily, a problem in terms of mediating, because the underlying issue there is not the fraud. Or even if it was a fraud, the question comes is, it might meet the statutory definition of a fraud vis-a-vis the person, but is it a fraud on the state? And if it's only a personal dispute or a personal issue, then what was the reason for the fraud? Is the reason fraud coming because of the act of the other party? And then how do you look at those interests?
Yes, ma'am.
Okay. And then if you look at, for people with disabilities, there's this entire exclusion there. Does it mean that they do not, and we're not looking at do they have the capacity to contract? And again, if you look at it now, if you're talking about you can't mediate, you can't settle. Now, what happens is to the interests and rights of certain people with disabilities. And one is, if I'm able to think with my mind and I'm able to make conscious decisions, okay, to what extent can the court interfere in decision that I want to take? That is, if I'm making a decision with respect to my life or my material or my assets. But if there's somebody who's mentally incapacitated and the guardian is making decisions, now there you could have under the Guardianship Act, or under that you can say, or you can say that with respect to such matters, while you might mediate, however, the final mediated settlement agreement will be subject to approval of, and you can give a high court, you can give something else, you can create a bench which will only look at oversight of certain kinds of mediated settlement agreements to ensure that they don't violate certain fundamental principles of law.
All right. Ekta, when you say disabilities, is it mentioned? Because this is entirely new information.
I will read out that to you. In fact, just give me 1 second.
I think it is persons with unsound mind.
No. It is okay. If you look at paragraph number 3 of Schedule 1, and I'll read it out. Disputes relating to claims against minors, deities, person with intellectual disabilities under paragraph 2 of the schedule, and person with disability having high support needs, as defined in clause R of section 2 of the Rights of Persons with Disabilities Act 2016. Persons with mental illness is defined in clause so and so of the Mental Health Care Act. Persons of unsound mind in relation to proceedings conducted, and suits for declaration of title against government, declaration having effect of right in rem. So this is paragraph 3 of the first schedule.
And the exception created for these parties or people with these disabilities is that they will have a guardian, or they are not coming under the purview.
The first schedule is a thing that you can't mediate.
All right, this is really surprising.
So therefore, therefore, when you're looking at some of those, of course, you need to study to what extent is Schedule 1 applicable. Will the court dilute it? Those are, of course, how do you look at interpretation? But the fact is, should it even be there?
Yeah. All right, because I think when we talk about community mediation, community justice, restorative justice, then these are the people, there is a major chunk of people with any kind of disability who would be interested in participating in that process. And keeping everybody out of the purview makes no sense.
Ma'am, but I feel that
Satvik, do you want to? Okay, you go ahead.
No, ma'am, but I feel it would also like put upon a constraint of pre-litigation mediation mandatory for these people. So you need that set of particularly trained people who can deal with the persons with disability.
That's it. When you talk about, no, see, at the end of the day, when we talk about persons with disability, I think more than anything else, we need to give them, there's an element of respect that we should have for everybody. And at the same time, we should not discount their abilities. See, if a person has a disability, even a mental, even if a child is severely autistic, the child still has a mind. The child still has a thought. The person still has a thought. The person may not be able to articulate it effectively, but there is still a thought there. And if we say that, we should not discount that. And we should give them the ability to express themselves the way they can. Now, if somebody is of unsound mind and contract act says if you're unsound mind, you're not able to contract. As long as I'm able to contract under the contract act, I should be able to mediate and have a settlement. And when I have a settlement, if it is to do with certain things which are, and I said, those boundaries can be, put in that, if it is a non-cognizable offense, or if it is something which is against public policy, or if it is something which, where it is a government, and because there are lots of government, kind of contracts also, which are government statutes under which you can't mediate also in first schedule, or if it is a dispute under any of those legislations, then it needs some sort of a confirmation from a court. So it does not mean that you take away the rights, but you bring in a confirmatory there so that the court can bless it and say that, okay, fine, we don't see anything wrong which is there in this mediation. It is in your wisdom. And the court's powers there should also be limited. They should not be able to go into the merits. Why did you? How did you? There should be limited powers that the court also has. Is it against public policy? Is it against something else? And they only determine that.
Yep.
Yes, I would definitely
I think
agree.
we have Akansha's hand raised there.
Yeah. So I was just thinking it from the point of view of consent, which is required before putting your dispute before any institution. So, for example, like I said, I am researching in restorative juvenile justice. So one of the criticism there is that there are guardians who take decisions for minors. So because they do not have the capacity to know what kind of consequences would follow if they are opting a mechanism which is different than court, because conventionally we treat court as the first mechanism for any dispute resolution. So if this exclusion which has been created has anything to do with the consent that they can give, and whether it would be an informed consent, knowing every aspect of it.
That's it. That could be the reason why it is there. But by putting everybody in the same bracket, there could be the people with disabilities who are able to give informed consent. And if they're able to give informed consent, I think this is very protectionist if you look at from a paragraph 3 perspective. One is okay, informed consent. Then the second one will maybe you'll not be at the level playing field as somebody you're negotiating with. So therefore, somebody could take you for a ride. I said that could be the rationale for it, but there's a wisdom of the legislature when they drafted the
No, I think you're absolutely right.
Yeah, so that exclusion cannot be made absolute. I was saying that exclusion cannot be made absolute. There can be some exceptions where, with the permission of court, they can take this dispute to the mediation, because otherwise also it is in the interest of all the parties to the dispute. So that is I agree.
But to my mind, there should not be a first schedule. Everything can be mediated. However, certain kinds of disputes need a confirmation of a particular authority to ensure that it doesn't violate certain broad principles, which the bill can then lay down.
Absolutely, I agree to that. And I am so happy that you highlighted the protectionist attitude there, Ekta, because that is the reason why mediation and restorative practices are not being included in gendered violence in India. any kind of violence against women, because it is there's this social constructivist view that women are weak and they need protection, and restoration in these offenses is beyond imagination.
But
That's
actually,
again
if you look at the POSH Act provides for conciliation, and the victim is given the power to conciliate. So in fact, the IC is required. That's, if I'm not mistaken, Section 11 of the POSH Act. So the IC is required to inform the victim that she has the ability to continue with the investigation or ask for conciliation, provided that the terms of conciliation or the conciliation agreement cannot include any payment of any kind. So she cannot ask for money.
Oh, nice. I think you have given me a lot to thought about. I'm writing a paper on it, Ekta. So thank you very much for that input. Yeah, good. Satvik, to you.
Yes, ma'am. Ma'am, the government as a litigant is kept outside the purview of this bill. Like, considering the fact the government is the biggest litigant itself in the India, ma'am, is it a wise decision to keep it outside of the purview of this bill?
In fact, if you look at the recommendations of the standing committee, they came up with the recommendations on the bill in July. They've actually recommended that the government on certain contracts and on certain terms, they should be allowed to mediate. Now, the challenge with the government becomes this, and this is even if you say government can mediate, I think we need to also look at from the practical perspective. Will the government settle? Okay. Yes, government is part of several investor-state disputes. There are part of international mediations. Settlements do happen. But now, if you look at a commercial contract where the government is a party, or a non-commercial contract where the government, or a non-commercial transaction where the government is a party, and you need to get into a settlement. Now, unless a specific set of regulations where they say the government could settle between these parameters, and that is set up on the terms on which the government who will go and tell the government that I will settle by leaving revenue out. Because eventually, if you look at it, there is a CAG audit that happens on all government transactions. And if there's wisdom used by somebody to say that I will settle at X, or I will raise certain monies that are payable to you, they're also under scrutiny from the public, because they are all trustees of the public. The trustees of public funds. So taking decisions by officers of the government might become a challenge, even if you let them mediate. So more than saying government, you can mediate or not mediate, I think there should be a framework in place also where the officers can, with full confidence, without being worried about what will happen 10 years later, be allowed to settle certain kinds of disputes up to a certain amount. So the government has to figure out administrative regulations where they should be allowed to freely settle by using commercial wisdom or principles of natural justice. Whether whether you have committees to decide it, whether there are rules and
Ekta, I've seen few PSUs in arbitrations.
Arbitration is adversary. See, arbitration, they don't decide. Arbitration tells me I follow. Okay, in mediation, the thing is, I agree. The mediation settlement agreement happens only if I agree. And what are the terms of my agreement? So if it is where the government has to get money, and the guy says, okay, the penalty interest, don't put 5% interest, those little waivers they might take. But if the government owes money and the government is holding back for something else, it'd be very difficult without adjudication for somebody to take a decision on that. Why, from a corporate commercial perspective, it might make business sense. And there, that commercial decision will also go up to the board, and the board will decide. So there's a collective wisdom there. But can the government do that? Or can an officer of the government do that? That is a question mark. And even if you can say they can do it, will they risk doing it?
Yeah. I think that's brilliant. So more than an external inquiry, it is internal inquiry that is needed from the government side.
So there has to be a safety mechanism provided within which people who need to take decisions are able to take decisions. and make sure that these matters don't get into court.
Nice.
Yes, ma'am. If you go to our next question, which is an interesting one, what relevance do the mediation council have under this bill, and who can be the member of the council, and like what are the powers of this council, of the members also?
I think Satvik, you're probably, I mean, a lot of people probably are you old. So when you say powers of the council, I can only think about, if anybody is remembered on Doordarshan, used to have this show called He-Man. He's a masters of the universe. So I think you could probably equate the mediation council to or in Star Wars, you have this entire, the council of ministers who sit there and say, okay, fine, now we will decide. So the mediation council is somewhat like that. They are the people who set out, what are the criteria to being eligible as a mediator. So if there's a training program, what training programs should comprise of before you can be considered a mediator who's accredited? What are the levels and layers of accreditation should be there? If you're a mediation service provider or a mediation institution, again, what do you need to, what eligibility you need to do to fulfill that? So they're basically the custodians of the practice of mediation. So you can compare it to whether, like, the Bar Council is for lawyers, you have the Medical Council for doctors, Mediation Council is for mediators. Now, the challenge that I have with the Mediation Council is how the construction is there. Okay, there are about 7 people who will form part of it. Out of that, 2 of them are officials of the government. One of them is from a chamber. The chairperson and the others, that were 3 of the others, who are considered to be, of course, and then you have the CEO also, who's an external person who will come there. But then the other 3 are people who probably have either academic or industry experience with knowledge of ADR. It is not mediation, it is mediation or ADR. So they could have nothing to do with mediation and have arbitration, but they're eligible, and they're appointed by the government. So while there are only 2 people who are government officials, you have 3 people who are appointed by the government. So which becomes 5. Or even so I'm saying, I'm negating the fact that, industry bodies, etc., there'll be some, even though they're appointed by government, they'll probably have some, they'll probably have more reflection of the industry than of the government, but still, the 3 people who are coming from the government. So the chances of, because the government has so much power in terms of appointment of the council, it could become extremely bureaucratic. It could be comprised of people who actually don't understand mediation. And mediation, unfortunately, is a subject that even today people are not able to really understand. Okay, like there's somebody who's telling me about a mediation that was done by a mediator, trained mediator, who was also an ex-adjudicatory authority, and I'm not taking which court or where it was. And the person said mediation failed because some documents were not filed. They said that, because you're not there, I will decide and tell you what to do. So I'm saying, so even if you look at that, we already have challenges with, in terms of the mediation process understanding between people who mediate as well. There are still confusion between, should I be facilitative, evaluative? How do I understand and how do I give, even if I do evaluative, how do I look at party autonomy? Should I do only facilitators? You still have lots of thoughts in the mind because mediation per se is very new to the country. On top of that, if you have a mediation council, which is not understanding the nuances of mediation or the mediation process, how will they resolve some of these issues that might come? If tomorrow there is a mediator can be accused of not complying with the principles of mediation which are set out in the bill itself, if it becomes an act. Now, if there are decisions to be taken with respect to that, how will the council even understand or legislate on that or give a clarification on that if they don't really understand the process?
Yes.
Sorry.
Is there a duration of their appointment mentioned?
There is a duration. The duration is mentioned there. I don't remember it offhand, but it's not a very long duration.
But I think reappointment
that is there.
That is there, right? Yeah.
Yeah. So you can. Okay. So one is you say that, if you are a chairperson or you are things, how many times can you be done? How many times? So those are, of course, and some of these issues, in fact, the issue of the appointment of government is something that even the standing committee highlighted. So the standing committee has actually said the constitution of the mediation council needs to be re-examined by the government.
Yep.
Ma'am, I have this one question. Like the people who are appointed as members of council by the government, does government take any pre-test or provide them with industrial training, which is required for the mediation?
It's still a draft bill. We don't even have the rules. We've not even reached the hatch stage. That is, that as I say, no, abhi kahani baki hai. So we have to see.
Yes, ma'am. Like I'm just about to ask, like, is there any provision for that? Like, you need to have certain amount of requirements.
Those will come in the rules. So all those requirements, you will have rules which will be formulated later.
Yeah.
So that's a different story altogether. The first is how much of government control should be there in the council. Okay. And in fact, I believe there should be a good representation from the judiciary, from the bar, from industry, okay, from academia. And people who have a certain level of, five. One is industry as in commercial industry. The other is the industry in terms of the mediation industry. From amongst mediators. Okay, so if you look at a representation of judiciary bar, you're taking care of the bench and the bar. You're taking care of commercial interests of industry, who are actually probably going to be a large number of disputes are coming from there. It could be through chambers of commerce that you have members from chambers of commerce, which actually the bill today recognizes one person coming from there. So you have from there. You have from academia, who probably brings in the element of research and understanding to it as well. And of course, the mediators bring in the element of how the practice is, what is the understanding, what are the issues that mediators face. And of course, you also have the government officers who will also be around, who will bring the voice of the government to make sure that because the mediation council is a public body, at least the principles of administrative law, natural justice, all those are sort of at least those boundaries are maintained.
And I think we also have to discuss about the powers of mediation council, because it cannot be a he-man. I totally agree with you.
How do you limit those powers? And if you limit the powers, then anything else goes beyond that. Who decides? Then you want the government to decide, or it becomes statutory. So if you look at, I don't think the draft in terms of powers is very different from what maybe the medical council has or the bar council has. And I think if you're talking about a body that will be regulating an entire industry, they need to have the flexibility to take certain decisions. But the thing is that who are those people who take the decisions? And you want that body to be fair, because if that body is fair and that body is, it takes care of significant amount of, the interest of the public it wishes to serve, then the rules, regulations, whatever the powers that they exercise will not be excessive.
Yep.
Yes,
ma'am. Can I ask participants in the meeting if they have any question? If you want to put your question in the chat box or raise your hands, we can entertain any question here.
We have a few questions in the chat box if you want to take them.
Yeah, I think I'm going from bottom up. Yeah, I'm going from bottom up. Satvik, do you want to tell me questions, or you want to let me know which questions, because I'm just scrolling up and down. So you can tell me which questions that you'd like me to answer, and then
I think Ekta Chandrika has her, if you allow her.
Yeah, Chandrika.
Good evening, ma'am.
Yeah, Chandrika.
Is my voice audible?
Yes, Chandrika, I can hear you loud.
Okay, thank you. Ma'am, actually, I am a company secretary and an advocate, and I'm doing my LLM in EDR. So I have a question. It's a general question. That question has always come in my mind, that how a young lawyer, that any advocate or just pass out a lawyer, become a mediator. That what is the proper process to become a mediator for a young lawyer? Because ma'am, the one point always someone tell me that by taking a 48 hours mediation training and 60 hours mediation training, and after that you will become a mediator. But ma'am, is it only that sufficient for to become a mediator for a young lawyer?
So first is, Chandrika, your question is actually a very loaded question. Okay. So and again, what I'm expressing right now is personal views. To be a mediator, and I'm coming to things. First is, as a mediator need not be a lawyer. Okay. But if you want to do court annexed mediation, you need to be a lawyer. Okay. There are several great mediators in the country and internationally who have nothing to do with the law. Secondly, mediation training is just the tip of the iceberg. To be a good mediator, you don't even need to be trained. Some of this is, in fact, there's a friend of mine who actually calls it mediator mindset. You should be able to understand issues, differences, and guide the parties to a conversation. When mediation used to happen several years ago, you didn't have this 40-hour training. The 40-hour training is so that you have some element, somebody gives you an idea it's like a snapshot, saying, these are broadly the things that you need. So I have done about 8 to 10 mediation trainings. I do at least one a year, okay, if not more. I'm doing my master's in mediation. I read on the subject a lot. I don't think with a 40-hour training, you can say, Acha, I know everything about mediation. Mediation is an ocean, and it also depends on what kind of a mediator you want to become. So in fact, there was a class I was taking where I actually asked the faculty there, we all talk about facilitative, evaluative, is there one kind? He says there is no one kind. And eventually he said, you need to ask yourself, what is the purpose for you to be a mediator? And for me, that has just stuck, that the purpose why you become a mediator. So there could be somebody who becomes a mediator that I want to keep court litigation pending out. Okay, that is my agenda. I will work with the parties. I will not force anything on the parties, but my style could be more evaluative than facilitative. Okay, but for you to take or even have a conversation on what is facilitative, what is evaluative, you need to understand them. While broadly, a 40-hour training will probably tell you that, this is facilitative, this is evaluative, but you need to probably always learn. So like a lawyer, you study in law school, it doesn't mean that it's the end of your journey. Every day is a learning. Every day you need to read. If you don't know your case laws, you will not be able to manage you won't be able to appear in court effectively. Similarly, if you want to do mediation, you need to understand people in the room. How do you understand body language? Yeah, mediation training will tell you body language is important. They'll tell you concentrate on eyes, nose, mouth, etc. They'll give you 5 examples, because in 40 hours, you can't do the entire thing about body language. They'll talk to you about active listening, but you need to keep practicing that active listening. So while 40 hours, I like 40 hours because for me, it's a lazy person's way out. It tells me at the top of the things what I need to figure out. Thereafter, it is my journey.
Ekta ma'am. So Kavita, I will get back to you, Kavita. Just 1 second. I'm sorry.
Okay.
Ekta, thank you for that answer. And I just wanted to add there, Chandrika, I am sharing a link in the chat box. So I love the fact, Ekta, when you said that it is a mindset training, and we also at Accords International, we talk about the learning mediation as a life skill. It is not
Absolutely.
magic that in those 40 to 45 hours, you will become a mediator and tomorrow you will sit and start mediating. So,
but what it does is it gives you a reflection. It starts your process of introspection and reflective on how you reflect on yourself. Because eventually, as a mediator, there's a lot of self-realization that you need to go through. When I'm speaking to people, when I'm talking to people in a conflict, how do I need to behave? What kind of questions I need to ask? It's about them, but how do I factor and how do I look at myself vis-a-vis trying to get them and understand them?
And I think there is one more thing which needs to be highlighted here, that in India, to become a court annexed mediator, you need to have minimum 10 years of practice.
Not necessary. Again, there it is court to court, but invariably there, one, you need to be a lawyer. You need to have 10 or 15 years, depending on which court you are as a lawyer, or you need to have been done an MCPC training by that court.
By that court.
Yeah. So for me, I'll give you my example. So I am enrolled in a particular state. I live in a different state. I'm not eligible to be a court annexed mediator here because my enrollment is else. So therefore, there are certain practical, local jurisdictional challenges that also come if you want to do court annexed mediation. So, Chandrika, for you to look at, and if you're interested as a lawyer, young lawyer to do court annex mediation, go to the court annex mediation center in your high court or the mediation center of the state you are in and ask them these questions. And they'll give you the answers. When does the next mediation training?
Yeah.
Oh,
And I
okay.
think, and Chandrika, you can also see the link in the chat box that I shared. So you
And
can
with
also
that
learn about
MCPC, and when you do that MCPC training, don't say that I've done that, it's enough. Then you can look at, because see, a mediation training by somebody like a coach will be far more in depth than what an MCPC will do. Because the curriculum that they will take into account more international sources. They will look at what is the current development. The MCPC training module was prepared in the year 2005. And they still follow that module. If you go to the Supreme Court's MCPC website, you'll actually find the manual. And they go by that by the book.
Yeah.
Oh, thank you so much, ma'am, for the guidance and for clearing my doubts. Thank you so much, ma'am.
You're welcome, Chandrika. Yeah.
I think Kavita had a question, Ekta. Kavita, are you still
Yes,
there?
ma'am.
Yeah.
My question is in the same line which Chandrika ma'am has. Actually, ma'am, when we talk about the young aspirants wanted to join as a mediator and take up a profession as a mediator, but then problem is they are devoid of observing the process, as the mediation is confidential process. So can you please highlight this, because many of my students are coming to me and then they are asking me, ma'am, can you have any contact number wherein we can observe the process and we can learn what are the skills to be applied during mediation process. So please highlight this, what
So
can be done.
So two things, Kavita. So one is that, when you look at from a perspective of observing what skill sets are there. So recently, SIMC and the Japan International Mediation Center, they had a joint protocol. So they had a live a mediation role play being done by professional mediators who actually gave a role play for an hour. And you had the head of SIMC giving a detailed explanation bit by bit. I don't know if it's available online, but there's some material that has been circulated. So maybe if it is there online, your students can look at it. So if there's, and that was a cross-cultural mediation that was being demonstrated, where when the lawyer said something or the counsel said something, Ms. Lee would interrupt and saying, this is now where they're trying to get interests out. This is where they're now trying to do that. And have you observed the body language? Now, when she asked the question, did you see how the body language changed? So like that, there are lots of role plays also available in public domain for training. So but those are exercises, role plays. But the processes are confidential, but with the permission of the parties, interns have attended mediation. So most of my mediations I do with institutions. I rarely do ad hoc because I prefer that a institution is able, better equipped to handle the logistics of a mediation than I could do it myself. So when I am doing a mediation there's invariably some intern of the institution who's sitting with me for the mediation. Okay, but they sit after parties consent. And they also then sign on the confidentiality document.
I am sharing a link in the chat box if you want to see. This is on our website, and it's a entire, just like SIMC, Ekta, it's a video by International Mediation Institute. So it's an intellectual property right mediation done by an actual mediator, and it's a very nice, interesting video, 45-minute video. So Kavita, you can share this with your students if you want.
Thank you so much, ma'am.
Kavita, I think for some of these things, you could actually reach out to Upasna, and because as a center, they actually do some of these programs and sessions. I'm sure they'll be able to figure something out with you.
Sure, ma'am. Ekta ma'am, did you recognize me? Kavita here from Vadodara MS University. We had one mediation series and you were there as a speaker.
Yeah, that was a while ago, but nice to interact. Yeah.
Yeah, good to see you, ma'am.
Nice seeing you.
Yeah.
Very nice. Thank you for joining, Kavita. Satvik,
Thank you.
over to you.
Yes, ma'am. If we continue. Ma'am, is it mandatory to get the mediation settlement agreement registered under this bill? And how will this help in getting this registered?
So again, I'm taking back to one of the first questions you asked me, Satvik, and you asked me about what are the things that I don't like about the bill. And that was one thing in terms of registration. But before we get into the question, as I said, no, the bill came about, and in July, you had the standing committee actually gave recommendations. And when it came to registration, the committee has actually recommended that they relook at registration because, if you're looking at registration, in my mind, the registration adds levels of bureaucracy around it. There'll be stamp duty payments. There could be delays. There could be confidentiality issues because once you get into a registry, what do you do? How do you do that? What happens if I don't register? While the bill today talks about the fact that, if you don't register, it's not that it holds it unenforceable. But then what are the consequences? Because there's a mandatory requirement to register. But if I don't register it, and you're saying it doesn't affect the enforceability of it, then what is the consequence? So then it becomes a penal consequence. So if I don't register, I'm facing a penal consequence. But is the intent for registration something like that? So I think if you go back to, and the way I think the intent for registration is probably to get data, to figure out where is mediation working out, and how many cases go into mediation, how many settlements do I have, how many fail. So if I have that statistics, is it something that I want to have a visibility over, or is it a factor of control that you do anything, you register because a court order gets registered? In the parallel, an arbitration award doesn't require any registration. So an arbitration award, I don't require registration. So why mediation? What's the purpose for it? So I don't understand the purpose of having a registration other than making it bureaucratically challenging. So if it's statistics, I think there are different ways to do statistics. Make sure that if it is, while of course ad hoc mediation becomes difficult to monitor, but at least when you're working with institutions, or of course court annex mediation, the numbers are already there. If you go to the State Legal Services Authority, you go there, you can actually figure out the data. How many mediations every year are referred, how many are successful, how many are ongoing, how many are failed. So that statistics is available. But with institutions, you can always say that the institution on a periodic basis has to give a report to the government saying that these many mediations were referred to us, these many were successful, these many failed. And what is the timeline? So statistics you can actually get from institutions.
Yes, ma'am. If you go to our next question, ma'am, I agree with your views regarding the registration of mediation settlement agreement. Ma'am, what is the scope of resolving international disputes via mediation in India? Like, we want you to discuss 3 points, which is like, it's a whole lot big question. If you want, like, you can first answer the first question and we can go step by step.
No, I think ask me the whole thing, because I will give you
Sure,
a larger, an overview in terms of a macro thing rather than in micro questions.
Yes, ma'am.
The question is in the chat box for everybody to read.
Yeah.
Ma'am, what is the scope when India is one of the parties? And what is the scope when India is just a forum for mediation, but not a party? And what is the enforceability of such an agreement regarding, this is all regarding resolving international disputes now via mediation in India? That's my question.
The first thing is, if you look at international disputes, the bill uses the word international commercial disputes. So the scope is, again, it is not all kinds of international disputes, it's commercial disputes. So you've limited the scope of mediation straight away. Okay. So then if I have a cross-border labor dispute, is it a commercial dispute? If I have a cross-border matrimonial issue, is it labor? So those are probably out of the perspective of the Mediation Act. It should not be. It should be consolidated. And this is again a recommendation that the committee has given as well. That there were objections saying that when you're looking at the bill, you're looking at, even for international disputes, you're narrowing it applicability to only few kinds of disputes. It should be wider. It should be any kind of cross-border disputes. Now, the second thing is, if you look at the bill and you look at the language of the bill, one is it talks about the bill is applicable only to mediations that happen in India.
Yes, ma'am.
Okay. Now, it's international because of who the parties are and habitually staying in the country or whatever it is, or having business in the country. Now, those are also not clearly defined terms. So this could be there. So the bill talks about mediations that happen in India. They don't talk about mediations that happen outside India, where one of the parties is Indian. Now that element, that leg, is not dealt with. Technically, that is where it becomes important, because we are signatory to the Singapore Convention, even though we have not ratified it. Now, so if there's mediation outside the country, there's nothing in the bill that talks about how will I enforce that settlement agreement. So that gray area ambiguity still continues to stay. I think, and that will continue till probably we ratify the Singapore Convention. Now, this issue was also highlighted and asked by the committee to the government. And the government didn't want, they said, because of certain reasons, we have not yet ratified the Singapore Convention. And therefore, for various reasons, we don't want the provisions of overseas settlement agreements to be enforced in India coming into the mediation bill right now. So that element of international disputes happening outside of India are not enforceable under there. Now, if it's international commercial disputes which are in India, they meet the definition of this international commercial settlement agreement, like Section 28 will apply to them as well. So there's no differentiation. The only challenge becomes is when you talk about in India and outside India. Now, if you look at, especially because of COVID, now when you have, and you have one wonderful one paragraph or one section or two sections on online mediation, there's nothing else. There's a large number of conflict resolution that's happening online. And if you've seen how, at least the lawyers in the room, the entire conversation between seat and venue for arbitration, we've been through how many different perspectives and views and thoughts on, is it seat, is it venue, is it where I sit, how do I draft the clause? Now, if you get into that, it's in India, we'll get into this dialogue with mediation also, because it's such a fluid place. I could have parties sitting in one place, other parties in another place, the mediators in the third place, the witnesses in the fourth place. Nobody's moving out of the chairs. It doesn't matter sometimes where the venue of the dispute is also, or the cause of action is, because it's such a voluntary process. So when you're looking at in India, the challenge becomes, what is in India? Is the mediation in India? Will the mediator sit in India and that's what it is? Is it the location of where the mediator is? Or the mediator could be traveling. He says, okay, fine, my next session, tomorrow today I'm in India, tomorrow I'll be in UK. I know we calendar a session, but I have 3 mediations. I'll take 1 hour with you. I'm fluid. So eventually it will probably boil down to how does my clause in my contract define mediate, where the seat or the venue is for the purpose of figuring out the territoriality. So to my mind, that is the way the bill is a challenge. And we will have a lot of difficulty into trying to figure out, is it a mediation that is covered in India or not?
Yes, ma'am.
Does it answer? I think it
what
sort
is
of
the
talks
scope? What is the scope when India is one of the parties, ma'am? What is the scope when India is one of the parties?
India is an Indian party. So India becomes a government, right? So then if you talk about India being a party, if you look at the government of India, and which relates to your question when you asked the government being a litigator. Now, if it's an investor-state dispute, then it goes under treaties. That's a different kind of discussion altogether. If it's a commercial dispute where the government of India is a party with somebody else, then are you acting in commercial act? If you're acting in a commercial thing, then you're like any other party to a mediation settlement agreement.
Yes, ma'am. Okay. We're just left with a couple of questions. Yeah. Who is a mediation service provider under this bill, and can the registered service providers mediate international disputes?
So when you're looking at mediation service providers, are people basically providing mediation services. Now, it could be, again, who would it be? What are the requirements? What are the criteria? What are the eligibility? All that will be formulated in the rules. But it's a good thing that the Act is recognizing, service providers. It's a good thing the Act is giving certain operational flexibility, freedom to certain service providers in terms of providing training, in terms of how they can handle disputes. There's a certain amount of clarity that's coming in. And if you remember the first question, I said, one of the things I like is that it's given sanctity to the service providers, which today we don't have. So and that will help in terms of improving the mediation ecosystem in the country itself. So that becomes very important. And handling international disputes, they're already doing so. So we already have mediation service providers in the country. They're already handling international disputes. Now, the thing is that if it's a dispute which is cited in India, jurisdiction in India, you take it under the Arbitration Conciliation Act. It becomes a conciliation. Otherwise there'll be international recognized principles. They'll be probably doing it under that. You actually have co-mediators where one of the mediators in India, maybe one is in the UK, depending on how the parties want to be. So today you actually have very fluid systems of how mediations can work in a cross-border settings. And you already have service providers who do that. And nothing in the act stopped them from doing it. The only thing is that if a mediation service provider probably tomorrow does an international dispute, whether it becomes a dispute or a conflict and the settlement agreement is recognized under the Mediation Act, or is it outside the scope of the Mediation Act becomes a question. From a handling of perspective, I don't think there is any restriction.
Certainly, ma'am. Your insights are extremely valuable, and I would like to ask the last question, which is the kind of general question from all the aspirants who want to pursue mediation. Ma'am, what are your final hopes and disappointments with this bill? And anything that you would like to share with our younger audience before we end our chat?
So if you look at it, and my biggest hope is that we actually have a mediation bill soon. We had the comments in July, but we've not seen any movement after that. I really hope that we see a revised version of the mediation bill soon. Taking into account the various observations that that different stakeholders have put, the recommendations of the committee. Some I do agree with, some I don't. But again, the public consultation actually brought out several interpretations, and there are several viewpoints, and some, all of them, not everybody can agree on them. But at least if a significant amount of the ones where there is a majority, where there's a majority of people who sort of agreed with something, if those are done, I think it's a good thing. So I'd like to see some more movement on the mediation bill soon. My disappointment is that for cross-border mediation, one is the ratification of the Singapore Convention. I think we should probably do it sooner than later. Out of 55 countries, India was one of the initial signatories. Okay, 10 countries have ratified. We haven't yet ratified. So I do hope that and my disappointment is that we've not factored in the provisions of Singapore or in bringing about changes to law so that we could ratify it, so that we can then say that we are one of the first few countries to also ratify the Singapore Convention. So that's my biggest disappointment, is I don't see that in the bill.
Yes, ma'am. And anything that you would like to share with our audience?
Yeah, Ekta, just industry insight, or if you know better, because this is the question I asked to all the mediators in the field, that when do you think the next draft is anticipated? As in, I know it's a question.
I lost you in the middle.
Yeah. When do you think we can expect the next draft? Because it's been too long since we are waiting.
I wish I knew the answer to that, but I'm just looking for answers to that.
All right. So because this is something, because somebody, as far as my understanding goes, if a bill goes to a parliamentary standing committee, then the process becomes all the more slower. And I am quite, I'm waiting for the next draft to come, because it will be a little comprehensive. So let's see.
I hope so.
Yeah. All right. Any advice, as Satvik just said? Satvik, can you repeat that part of your question, please?
Ma'am, I was just asking, like, anything that you could share with our audience before we end our chat today?
I'd be happy to take questions, more than anything else.
Certain people have just written in the chat box that what do we need to do to become a mediator? How to, basically it's the deal right now.
Catch hold of Upasana to start with. Catch hold of Upasana to start with. If you want to be a mediator, I think you should catch hold of Upasana to start with. I think that's the first step.
Thank you. And I am sharing the link. I've already shared that. I'll again share the link of the training that Accords International provide. Since we're talking about this, our second cohort is in the month of January, February. You can look up the upcoming training. It's a 60-hour training that Accords International provides, and it's an accredited training. So this is the link for the training in the chat box. And there are few questions regarding reading. So there is quite a lot of literature on mediation, which talks about how to be a good mediator. But reading, you will not get a certificate of being a mediator by reading, and a certificate is also not required to be a mediator. All right. So I think you can read more about our upcoming mediation training, and I think there is a lot of material available online, as in terms of these fireside chats and other events. Just like Ekta just mentioned, that there are role plays available or made available by SIMC, IMI, even on our YouTube channel. You can go and learn more, because we talk about different aspects of mediation. Recently, we were talking about mediation advocacy, because to be very frank and honest, see, if today you get trained even by MCPC as a lawyer, you will not get placed in a court and next mediation center tomorrow. But if you get a mindset training as a mediator today, tomorrow you will be a better lawyer to be a part of a mediation. And lawyers are getting a lot of opportunities in mediation training, in mediation processes.
I would
So
not like to limit a person, just things. One is, I would not limit it to lawyers. People who are interested in bringing about change. And if you look at even restorative justice, as a psychologist, there's just so much of opportunity in terms of how you can do. Because see, you have complementary trainings for whether it's psychology, whether it's coaching, whether it is law, whether it's philosophy. There are just so much complementary which is going on that, if you look at mediation, and mediation training becomes a skill set. It's more of a skilling than of a profession. And for me, I use my mediation in my core transactional work as well, because it helps me. So when I look at a document or I look at an agreement, my first thing is, okay, what are the interests I'm looking at? Okay. Once I try to, I'm doing a button right there, because I'm trying to figure out what are the interests that my client, because my client will talk to me. So I have visibility and interest, but I do not have visibility and interest. So from the document, I'm trying to figure out what are the interests that I should try to see, and where are probably places where I might see impasses, and then what kind of conversations I need to have with my client. So if I look at my mediation training and the kind of things I've learned in mediation, the application of that is something I use even in a non-mediation setting.
I think I completely agree.
I have
Yeah, please
one
go ahead,
question.
Satvik.
I have just one question which I wanted to ask, ma'am.
Yeah.
It is my question, not on behalf of Accords International. Actually, I was quite excited to go into international energy and infrastructure disputes, ma'am, and like that made my move towards the procedures of ADR eventually into mediation. Currently, I'm working with Accords International. Like what I feel is building the mindset of and skill set is like critical things to become the best in anything. I mean, in the field of law. Ma'am, you have been through a journey of 15, 20 years plus in the field of law. Like, what do you suggest to someone who is starting, for example, just about to get completed with their studies, legal studies in like a couple of years, or who have just completed their studies? What are the major, like, what is that, how to build that kind of mindset and skill set, ma'am, over the period of, because here the sustainability is the most important part. Like,
there is no shortcut to learning. There's no shortcut to learning. Okay. Keep an open mind, explore, figure out who you are. See, first, there'll be 10 people who are doing something. Okay. But if it's not you, no matter how hard you try, you'll be miserable. So first is explore. Okay. Keep an open mind, learn. Okay. We are students for life. So that learning is a continuous process. So, and so once you do that, and if you understand who you are, the next steps are very easy, because you'll figure yourself out.
Yes, ma'am. Definitely.
Absolutely, Pasna. Grit. Very important.
That's what my senior told me when I was entering the profession. He gave me the rope and he told me, fight it with grit. So I think that's very important. You have to stay there. with strength. And I think, Satvik, you never know. You can be a lawyer today. You can be a mediator tomorrow. You can be a teacher day after. So I am a lawyer by profession, academician by choice, mediator by interest, RJ facilitator by affiliation with Akanksha, and always a student.
And Satvik,
So
my
you-
journey to mediation started 15 years after I became a lawyer.
Yeah.
Okay. And as I said, so for me, and life is evolving. Life is never static. So there are always newer things. And it's for me, it's the journey. It's more than a journey than anything else. And it's about discovery. There could be things that you find great today. And like even in mediation, it's not just one kind of mediation. What kind of things would you like to do? Are you somebody who's corporate commercial? Are you somebody who's families? Are you somebody who's restorative? Are you somebody who's looking at investor state? Are you somebody who loves mediation but also likes the charm of adjudication? So are you somebody who likes to look at, say, Arb Med Arb, and I want to be somebody who wears two hats? So there are lots of avenues open, but if you don't understand what kind of person you are, your choices will depend on what you've seen other people do without realizing what works for you. So while it's important to explore, because then you got to know more what people are doing and what opportunities are available, you'll also understand what kind of skill sets you like for something you need, for something that you want to do because you love it.
Yes, ma'am. Thank you so much, ma'am.
Yeah,
Thank
I
you.
would like to give my podium to Upasana.
Thank you, Satvik. So I think, Ekta, it has been a lovely chat. Most of our participants stay till the end, and I'm telling you, 9:50 p.m. in India, and it's actually very. I'm happy to see that there was so much of an interaction throughout the chat. Your positivity and your energy made the topic more interesting, and thank you for that. Thank you for taking out time on a weekday, and it was lovely having you over.
Thank you so much, Upasana. But all the credit actually goes to Satvik, because if he hadn't asked the kind of questions, I wouldn't have been able to give these answers. So, Satvik, thank you so much. It was a lovely,
It's my privilege
lovely conversation happening. That I had with you. Thank you so much.
It's my privilege, ma'am.
And
Because
questions, Kavita and Chandra, that their questions also were very, very, very interesting. Because there's always a journey that starts somewhere.
Yeah. All right. Thank you very much, Ekta. If we can have a picture before we say goodbye, if anybody wants to switch on their cameras, we can have a quick picture. Akansha, are you going to take the picture? Right. All right. So I think we have enough cameras switched on. Whenever you want to stay, I'm smiling. Done? All right. Thank you very much. I'll send it across, Ekta. Thank you for taking out the time.
Thank you so much.
Have a good night, everybody. Bye-bye.
Thank you for staying so late. Good night. Bye.
Good night.
Good night.
Good night, everyone.